Good morning to everyone and welcome. We're going to go ahead and start on time. This is the new government. We're actually starting on time. We'll finish on time. Thank you very much for coming in. Some explanation of how we're going to proceed today. I was just telling the ranking member, Mrs. Chu, that ordinarily when we have these 10 o'clock meetings, we are under the gun with votes that are imminent. We've just learned that we will not have votes probably till around noon today. So I will be a little slower with a gavel. If you go over a few minutes on your opening testimony, that would be great. We'll also give more latitude to the members in their 5 minutes of questioning. As I was discussing with Ms. Carroll before the hearing, 5 minutes, if you haven't done this before, really isn't that long a period of time. And this is an important topic that I think it's important enough for us to build a good, solid record on all sides of this issue. So we're going to try and do this as thoroughly as we can today. The order of business is I'll give a brief opening statement. Ms. Chu will give her opening statement as the ranking member. Then we'll introduce each of the witnesses. We'll introduce them together, and then we'll have you take your testimony, and then we'll go back and give every member of the committee a chance to ask a round of questions. I'll then make a closing statement, as will Mrs. Chu, and we'll wrap up. So, again, thank you. We're going to go ahead and call the meeting to order. And thank you again for participating. In 1987, Ronald Reagan brought attention to the need for the Federal Government to procure commercial goods and services for the best value, whether from government employees or from the private sector. He recognized that inherently governmental work should be performed by government employees, but that at the same time, inherently non-governmental functions could and should be performed by the private sector, including small business. Such an outsourcing of non-governmental functions would encourage private growth, help small business, and actually save the taxpayer money. Toward that end, we support the continued insourcing of inherently governmental work. This hearing, then, is not about outsourcing military operations, for example. This hearing is about the recent push to insource inherently non-governmental work for alleged cost savings. Over the past 5 years, primarily at the Department of Defense, there have been concerted efforts to take commercial or non-governmental functions performed by the private sector and make them a permanent government function. In the 2006 National Defense Authorization Act, the Secretary of Defense was instructed to ensure that consideration is given to using Federal Government employees for any work done by Federal employees since 1980, and any work that is inherently governmental was not competitively awarded or was poorly performed due to excessive costs or inferior quality. In the 2008 National Defense Authorization Act, that guidance was expanded and codified to ensure that the Department of Defense civilian employees are used on a regular basis to perform activities that are currently performed by contractors but could be performed by Federal employees. In 2009, insourcing was expanded even further to include agencies outside the DoD, and agencies were directed to produce specific guidance on insourcing. We're still waiting on much of that insourcing guidance from the civilian agencies. However, this lack of guidance has not stopped those agencies from insourcing, but has merely meant that the insourcing that is being done without any transparency or without any regular process. Even at the Department of Defense, where there is a detailed guidance on insourcing, the cost comparisons used to justify insourcing commercial or non-inherently governmental work previously performed by small business has not held up to scrutiny, yet there is no process for the small businesses to challenge the decisions. Insourcing was initially sold as a way to save the Department of Defense as much as 40%. President Obama claimed that it would save as much as $40 billion a year. However, after years of implementing this policy, the Department of Defense has admitted that they have not achieved significant cost savings. In fact, in February, the Army froze all insourcing efforts without direct approval of the Secretary due to cost increases. Our national debt stands at $14.3 trillion. Our Federal deficit is higher now than at any point since World War II. The Federal budget comes in at $3.7 trillion, a quarter of our entire GDP. And the Federal workforce has expanded to over 2.1 million employees. We need to find ways to both reduce spending and to keep it low. Continuing the policy of insourcing commercial functions without demonstrable cost savings increases the size and the cost of the Federal Government and moves us in exactly the wrong direction. When the government chooses to consider insourcing, the burden should fall on the government agencies to prove that the full long-term cost, including pay, benefits, and support, of hiring and training new Federal employees is in fact less than a temporary government contract. Recent reports indicate that it is not. I want to thank the small businesses that have come here today to testify about the lack of transparency in the insourcing process and the need to reform the process to ensure that taxpayer dollars are being used to maximize productivity and not to maximize government employment or union membership. I would also like to thank the work of outside groups, including the Business Coalition for Fair Competition, for documenting the many instances in which the government has sought to compete directly with small business to provide commercial items to the Federal Government. I look forward to hearing from the small businesses that will testify today about how insourcing has affected them individually. And again, I want to thank everyone for their participation. I will yield now to Mrs. Chu, the ranking member, for her opening statement.
Thank you, Mr. Chair. The Federal Government buys a wide range of goods and services annually, running the gamut from office supplies and janitorial services to aircraft and engineering services. In the last decade, such procurement spending has doubled to more than $500 million as policy changes encouraged more and more services to be contracted out to the private sector. With this rapid growth in mind, it's appropriate that we consider the impact of these policies not only on the private sector, but also on the government itself. Over the years, and as administrations have changed, the government's reliance on the private sector has ebbed and flowed. These changes have had a direct effect on the private sector and small businesses in particular with regard to their ability to secure Federal contracts. Conversely, it's also affected agencies which now rely on private sector corporations to carry out many functions. Determining the proper balance of these public-private arrangements is critical to increasing efficiency and reducing cost. Across agencies, this balance varies, and often there can be disagreements over what is inherently governmental. It's not uncommon for the purchasing needs, management responsibilities, and overall spending related to certain similar tasks to differ across the executive branch. As a result, many agencies have taken steps to better achieve their core missions. Such rebalancing efforts have been used to ensure that inherently governmental functions be performed by Federal employees. In other cases, the process has been used so that agencies can build their capacity and capabilities in certain critical areas. In doing so, agencies have implemented new processes to review their responsibilities and determine which functions should be retained in-house and which should be conducted by a vendor. In many cases, the process has been complicated. In instances where cost is the primary justification for rebalancing, there's been some disagreement as to the method used to determine which functions are selected. There is a tension here, and we must recognize agencies' desire to retain inherently governmental functions, but also fairly treat small businesses that are currently or may want to in the future perform these tasks. To make certain that small businesses are respected in these processes, transparency is a key. It's important that small firms that are provided with full and complete information regarding why these efforts are being undertaken, but also made a means for them to contest any inequitable treatment that they may be subjected to. Doing so can ensure that agencies can proceed with such efforts, but in a manner in which small firms are respected. The effect of these transformational practices on small businesses has been recognized by administration officials. Agencies have been advised to place a lower priority on reviewing work performed by small firms in certain instances. While this is an important first step in ensuring fair participation by small businesses in Federal contracting, additional examination is needed. While we may not be able to always outsource contracts to small businesses, we must do what we can to diminish the impact on them. Today, this hearing will focus on the process of how functions are selected for Federal performance, examine the effects that it has on small firms, and identify steps to improve the process so that we can determine the appropriate balance between functions that should be performed by Federal agencies and the private sector. We will hear from a number of witnesses who will provide different perspectives on these practices and the challenges they have presented. I want to thank all the witnesses who have traveled here today for both their participation and their insights, and I look forward to hearing their information about this important topic. Thank you, and I yield back.
Thank you, Ms. Chu. It's a great panel. Looking forward to it. First, we have Dawn Hamilton. Ms. Hamilton is the President and CEO of Security Assistance Corporation, a Virginia-based small, disadvantaged, woman-owned 8A business, which she formed in 2003. And Ms. Hamilton will be telling us about her personal experiences with insourcing, specifically, I believe, at the Coast Guard. Next, we have Bonnie Carroll. the president of Information International Associates, a woman-owned small business headquartered in Oak Ridge, Tennessee. They provide information management systems and technology services to the government, academia, the private sector, and international entities. Ms. Carroll will be testifying regarding having her personal experience with having 3 contracts insourced. Finally, we have Bryant S. Baines, the managing shareholder at Neal, Hooper and Baines. Mr. Baines formerly practiced government contract law on behalf of the Department of Justice and for 8 years active duty as a Judge Advocate General. Thank you for your service, Mr. Baines. Mr. Baines has taught government contracting at George Mason and the U.S. Army's Judge Advocate General's School. He will be talking to us today about issues of standing in insourcing cases, something that only lawyers could really appreciate, Mr. Baines, so thank you for doing that, as well as the recent Court of Federal Claims case, Hallmark Phoenix 3 versus the United States. And I'll yield now briefly to the ranking member for the introduction of the 4th witness.
Yes, I'd like to introduce Jackie Simon, Director of Public Policy of the American Federation of Government Employees. Thank you for being here.
Very well. Ms. Hamilton, if you begin, you've got roughly 5 minutes, but again, we're going to be a little slow with the gavel today, so don't feel the need to rush.
Chairman Mulvaney, Ranking Member Chu, and distinguished members on the Subcommittee on Contracting Workforce, thank you for inviting me today to discuss my experiences with respect to the implementation of the current administration's insourcing policies. I'm Dawn Hamilton, President and CEO of Security Assistance Corporation. SAC was founded in 2002 and is a small, disadvantaged, minority, woman-owned, SBA-certified 8A security services provider. In September 2008, the Coast Guard awarded SAC a small business set-aside contract to process merchant mariner applications at the National Maritime Center in Martinsburg, West Virginia. This work is comprised of 3 task orders. Shortly after receiving the contract, SAC instituted various process improvements at the NMC to alleviate a significant backlog in merchant mariner applications. As a result of SAC's process improvements, the credentialing process is significantly improved today. For this work, the Coast Guard has recognized SAC for its outstanding performance and contribution to the Coast Guard's receiving the Alexander Hamilton Award. Notwithstanding SAC's exceptional performance, and without any warning, on December 23, 2010, I received a call from Coast Guard headquarters stating that they would be insourcing 2 of the task orders. By the end of the business day, the Coast Guard posted the relevant position on the USA Jobs website. Soon after being informed of this insourcing action, SAC requested the cost analysis and documents that allegedly justified the insourcing action, which revealed that the positions at issue were not inherently governmental. The Coast Guard's insourcing process failed to provide SAC with an opportunity to provide actual cost data or respond to this action. The cost analysis was incomplete and inaccurate. It underestimated significant costs, including indirect costs, the cost of additional positions, salary, transition, short-term, and training costs. The cost analysis justification and conclusions were also unsupported. The analysis stated without authority that the cost of a contractor is automatically higher than the cost of a government employee, and that the insourcing would have no adverse impacts to other organizations. This obviously is incorrect, since this insourcing action has the potential of putting SAC out of business. SAC repeatedly attempted to meet with the Coast Guard to present its findings. When the Coast Guard finally met with SAC, we apprised the Coast Guard of the faulty process and offered to provide actual cost information. In response, the Coast Guard stated they had performed a robust cost analysis, had spent significant time and resources on their analysis, and had no interest in reviewing SAC's actual cost data. SAC then met with the Small Business Administration officials, for which the first time have attempted to effectively intervene in an insourcing action. Specifically, the SBA Procurement Center representative has requested the Coast Guard halt the insourcing action until it is able to conduct a true cost and impact analysis and discuss the results with the SBA. Regardless, the Coast Guard is moving forward with the action and has already extended offers to over 55 of SAC's employees. In fact, the number of SAC's employees insourced represents approximately 23% of all the Coast Guard insourcing for the last 2 years. There is no question that the insourcing of these task orders have profoundly affected the future viability of SAC. This action has directly resulted in the loss of 75% of SAC's jobs and revenue. SAC respectfully submits the following recommendations. 1, that a moratorium be placed on all cost-based insourcing actions until further government-wide procedures are in place. 2, that the Federal Government adopt government-wide procedures through a public rulemaking process. At a minimum, such procedures should include A, requirements that affected companies and organizations be provided with all government cost data and analyses used in making an adverse insourcing action. B, an impact analysis for insourcing actions that affect small businesses, and C, an appeal process for affected companies and organizations. And finally, 3, that the SBA be given a defined role in the review of agency insourcing actions. In summary, the positions at issue in the insourcing action taken against SAC are not inherently governmental functions. Rather, the Coast Guard claims it was done to save money. The cost analysis provided by the Coast Guard is riddled with problems and is ultimately inconclusive of whether the Federal Government will realize any cost savings. What is certain is that the Coast Guard's actions have inflicted real and actual harm to my small business, cutting jobs and revenue during this economic downturn by up to 75%. Going forward, it is imperative that the impact on small businesses, the driver of our economy, must be a required consideration in any future insourcing action. I appreciate your time and attention today and look forward to answering any questions that you may have. Thank you.
Thank you, Ms. Hamilton. And by the way, thank you, Ms. Hamilton. By the way, just an explanation of the lights in front of you. Again, we're going to be a little looser with the time, but I don't know if you actually see the amount of time or if you just see red, yellow, and green. Green obviously means that there's more than a minute left. Yellow means there's a minute. Red means that we've ended the 5 minutes. If we go much over 5, you'll hear a light tapping minute, just a light tapping sound, just to bring to your attention the fact it's time to wrap up. But again, we'll be fairly loose with the time. So thank you, Ms. Hamilton. Ms. Carroll, would you please begin with your testimony?
Chairman Mulvaney, Ranking Member Chu, and members of the subcommittee. I appreciate the invitation and opportunity to provide testimony on this very important issue. In addition to being president of Information International Associates, I'm also a member of the Professional Services Council and serve on their board, so I'm pleased to testify on behalf of many other small businesses at PSC. The insourcing actions that we have had that was most significant impact on us has been for the Department of Defense and particularly the Air Force, so I'll focus a little bit on our experiences from the Air Force today. But similar activities are taking place across the government. We are proud of the quality and level of service we provide the nation's military men and women. We have done work on over 15 Air Force bases. Our contract performance has been outstanding. Our contract prices have saved as much as 33% over previous government in-house costs. Our work has never been identified as inherently governmental. In fact, we continue to do that work, as do other contractors across the whole Air Force. Yet, despite these performance metrics, we've lost 16% of our employees to insourcing by the Air Force over the last 8 months, and we hear rumblings about the potential for another 15%. Amen when I say we do agree with the strategic need of the Federal Government to strengthen performance of inherently governmental functions, particularly the Federal acquisition workforce, and also in areas where the government must have internal expertise to manage agency mission. Coming from Oak Ridge, I hope the government has internal nuclear expertise. Where insourcing fulfills a validated strategic need, we support its proper use. As a taxpayer, of course, I wholeheartedly support saving the taxpayers' money. However, the tactical methods of implementing the insourcing requirement and the impacts on the Air Force mission raise grave concerns for us. What we have observed is that decisions to insource are driven more by arbitrary budget and manpower bogeys than by the objectives of enhancing the government's workforce capabilities or by true cost savings. Furthermore, the reprehensible tactics of directly recruiting our staff before official notice is given about the government's even decision to insource is highly inappropriate. Finally, where insourcing decisions were based on cost savings, the cost analysis of how the deliberations were made have not been transparent. and there really is no effective mechanism for a contractor to gain enough information in appropriate time. In addition to the faults in the decision and transition process, once the insourcing occurs, we do not believe that there is any meaningful internal or external oversight to ensure that the claimed savings and desired program's objectives have been achieved. In fact, quite the contrary. What we see is evidence that insourced positions have not been fulfilled and services to our warfighters have in fact been diminished. In my written testimony, I provided 3 case studies where outsourcing has occurred to the detriment of my company. Rather than going into the details here, I would like to address some recommendations that can be done to perhaps fix some of the problems created by inappropriate insourcing. First, in the issue of transparency, and I think we're saying many of the same things, Congress should insist on more transparency for any contract which is considered for insourcing. From the moment the consideration begins, some kind of an ombudsman or ombuds process should be appointed to work with industry to assure an appropriate and fair process is followed. Another recommendation in transparency, as part of that process, actions taken to fulfill the requirements should be documented and made available to the contractor before contracts are terminated. Going through the FOIA route is not giving people information when they need it to have any kind of reasonable ability to take action. Next, in the issue of competition. When the government is pricing a contracted function, the contractor also should be allowed to put in a price to ensure that the taxpayer is indeed getting the best price. 5 years after a contract begins, the contractor might in fact have lower prices to offer. Unless there is significant and special justification in insourcing, small businesses should be allowed to complete the contract with all of the options exercised and not stopped in the middle. Special justification should be required. Transition planning and consequences. And I emphasize the word consequences. The government should demonstrate that it can transition the contract just as a contractor would be required to meet a transition plan. There should be consequences to the government's failure, just like there are to a contractor when commitments are not met. Ongoing reviews of process during performance should be required. This is like the letter of obligation that's applicable under A76, and some form of it should be used and enforced. And finally, and probably most problematic, is inappropriate recruitment. Poaching, and I hope you've heard that word before, and other questionable recruitment practices aimed at contractor employees on contracts targeted for conversion should be dealt with. It's against regulations, and it has a significant financial impact on the contractor. We recommend where the workforce is converted from private to public sector positions, the government should actually compensate contractors for the cost of hiring and training those personnel. If the government did not take them over, they would have to incur these costs. At a minimum, these costs should be considered in the cost analysis. So we are proud to do the work we do and are proud to support the important missions of our government. What we ask for is fair opportunity to compete and a government that makes the right decisions for the right reasons. Thank you for the opportunity to testify, and I am pleased to answer questions.
Thank you, Ms. Carroll. We're going to hold off the questions to the very end. So, Mr. Baines.
Mr. Chairman, Ranking Member Chu, distinguished members of this subcommittee, it's an honor and a privilege to talk to you today about the legal developments and about in insourcing, their adverse impacts on small business and job creation, and the lack of transparency in the process. More specifically, I have been asked to talk to you today about the recent decision by the U.S. Court of Federal Claims and Hallmark Phoenix 3, LLC versus United States. In this case, I want everybody to understand that the Court of Federal Claims, one judge on the Court of Federal Claims, issued a decision ruling that the court lacks jurisdiction to review insourcing decisions by the federal government because private contractors are not within the zone of interest of the applicable statutes. This was a Defense Department insourcing action by the Air Force, specifically United States Air Force, U.S. Air Force Space Command, and it concerned a contract that was far from inherently governmental or anything close to that. I'd like to talk to you about this today because it is a very, very bad thing once we understand that we can no longer question our government, that we do not have the right to go into court and say, stop, take a look at this, and is it the right thing to do? In this case, that's exactly what the court said. It looked at the statutes at issue, namely 10 U.S.C. 129A and 2463, the Defense Department's insourcing statutes, and decided that private contractors have no right to question the government's insourcing in court, saying that that is for the halls of Congress. Well, we are here today. And I would echo the concerns of my distinguished colleagues in the private contractor community. I see the same things where I am. For several contractors, I represent several that have been subject to insourcing. And it is interesting to talk about Hallmark today, because that is an excellent example of insourcing gone awry. The Hallmark contract is a transportation contract and vehicle maintenance contract. It has it concerns it does not concern weapons. It does not concern policy making. It was competitively awarded. The contractor has no adverse performance history. In fact, did a very good job. And from what we can tell, they were doing the work in a very, very cost-effective manner. That was the statutes at issue that we're talking about require the least cost form of manpower, either military, civilian, or private contractor, when you're looking at whether or not to do insourcing. The court, when it was looking at it, said that, well, no, you cannot look at, you can't question the analysis that they did, because you're not within the zone of interest in legal parlance. In other words, this statute was not passed for your benefit. But when you look at 10 U.S.C. Section 129A, it does say, and it mandates from Congress, that the least costly form of manpower be used. And it specifically states military, federal civilian, or private contractor. Now, if a private contractor is the least costly form of manpower, which in the Hallmark case we believed it was, then that would make a private contractor the beneficiary of that statute, and one that should get the contract, and it should stay outsourced. But for a host of legal reasons that we don't have enough time to go into here, the court decided that private contractors had no legitimate right to question that action. There was a CRS report, a Congressional Research Service report, issued earlier this year titled Functions Performed by Federal Contractors, an Overview of the Legal Issues. This is an excellent report, and it talked about in it an analysis that the current administration was doing. And this is in line with some of the recommendations we're going to make today. When we're looking at how we fix the problem of whether we can question insourcing in court, we have to do three things, I think, to make sure that no court in the future denies that opportunity. First of all, we need to amend the Competition and Contracting Act to define protest to include conversion of a function that is being performed by private contractors to federal, civilian, or military employee performance. Second, we need to amend the Competition and Contracting Act to provide that prudential standing in a protest action is coextensive with interested party status. And three, I think it's appropriate to impose a legislative moratorium on insourcing, the one that was named in the CRS report, until the administration completes an evaluation of the impact of insourcing on small business and the general overall cost savings. This is key because when you look at this, when in the Hallmark case, when we talked to the people at Air Force Space Command, we learned that they had not asked any of these questions. They specifically told us that we have not considered the impact on small business. We have not considered the impact on the union workforces that will lose their jobs, and there is no direct hire authority. So in that context, that was another reason that we had to question the insourcing in court. Because the administration has not considered these things and has had no emphasis placed on considering these things, that is why we recommend putting the brakes on this today.
Thank you, Mr. Baines. And Ms. Simon?
Mr. Chairman, Ranking Member Chu, and members of the committee, thank you for the opportunity to discuss the importance of insourcing in reducing the federal government's expensive and risky over-reliance on service contractors. For the uninitiated, there's no better reminder of how insourcing can be used to save money and improve services than the retirement and annuity work at the Defense Finance and Accounting Service, or DFAS. In 2001, the work was privatized. In 2003, the DoD Inspector General determined that the decision to contract out had been wrong and reported that a systematic flaw biased the A-76 process against the in-house workforce and raised serious questions about the integrity of all A-76 cost comparisons. Despite growing concerns over the contractor's poor performance, including reports that thousands of military retirees with disabilities died before they received their benefits, DFAS did not actually decide to insource the work until 2010. DFAS's decision to insource 600 jobs saved money and improved services because, according to the agency, federal employees were more flexible, were better able to change the way they worked, and to accommodate increases in demand. In 2011, DFAS told the House Defense Appropriations Subcommittee that this insourcing would save $5 to $10 million this year and $19 million in the next fiscal year. As DoD reported in December 2010 regarding its overall insourcing, and I quote, "Execution to date has been highly successful. More than half of current insourcing actions are because the contracted work was determined to be inherently governmental, closely associated with inherently governmental, or otherwise exempt from private sector performance to mitigate risk, ensure continuity of operations, build internal capacity, meet readiness needs, etc." End quote. Also, according to DoD, quote, "Moreover, on a case-by-case basis at the organizational level, DoD components are finding that they can generate savings or efficiencies through insourcing certain types of services or functions." Regardless of what is said today, this hearing has provided a very valuable service because we now know that of the almost 17,000 in-house positions created in DoD through insourcing in 2010, just 6% were established where the prime contract holder was a small business. Although not the final word, DoD's 6% report is the first set of undisputed facts to be introduced in a debate rife with disinformation and misinformation. Here's a bit of historical context. During 2010, when DoD actually insourced, it spent a record $248 billion on service contracts, a huge increase from the $104 billion spent in 2001. Civilian personnel costs during that same period increased from $41 billion to $69 billion. And a little bit about proportions. I think defense service contractors would have a very difficult time convincing taxpayers they've been victimized by insourcing when there's been such a large net increase in service contracting, a $5 billion net increase in 2010, despite insourcing. Insourcing affected less than 1% of contracted out work at DoD in 2010. As we have seen, insourcing can be used to improve service, save money, and reassert public control over public functions. Federal employees are often far more flexible than contractors because they don't insist on lengthy negotiations and costly surcharges every time something unanticipated occurs. Yet despite significant savings from reducing over-reliance on contractors, DoD insourcing has all but stopped. DoD is no longer managing its workforce based on the usual criteria of cost, policy, risk, and the law. Instead, it's not assigning work to federal employees. Indeed, it's taking away work from federal employees merely because they're federal employees, which inevitably undermines the interests of taxpayers and warfighters. It's also important to understand that the insourcing laws don't cover conversions to performance by military or reserve personnel. This hasn't stopped lawmakers from offering draconian amendments to stop insourcing, even when the so-called horror stories that inspired them actually involve insourcing to military or reserve personnel, not to federal employees. The insourcing laws also have nothing to do with contracts that are terminated simply because the agency no longer needs the work to be performed. I realize that both of those points are obvious, but the vast majority of alleged horror stories we've been presented with are actually contracts that aren't continued or have been converted to performance by military and reserve personnel. At a time of large budget deficits, it's important that contractors, both big and small, be required to make the same sacrifices that rank-and-file federal employees are already making. Proposals to prevent managers from using federal employees instead of contractors, even when money would be saved for taxpayers, are indefensible. Contractors consume enormous amounts of discretionary spending. No effort to reduce the burden of contractors on the taxpayer can be taken seriously if it does not allow managers to substitute federal employees for contractors when savings are possible. This concludes my statement. I'd be happy to answer any questions members of the committee may have.
Thank you, Ms. Simon, and thank you to everybody. As is my practice, I will defer first to Mrs. Chu and then allow the members who are participating to ask their questions, and I'll hold my questions to the end. So, Ms. Chu, you have as much time as you need.
Thank you, Mr. Chair. Ms. Simon, last year the Department of Defense instituted the Efficiency Initiative to reduce taxpayer costs by increasing efficiencies and eliminating redundant functions, and you have talked in detail about that. What was the impact on insourcing, and why is it important that agencies comply with the laws that require them to inventory their service contracts?
Well, I'll answer the second part of your question first, if that's okay. One of the reasons bipartisan majorities of the Congress have endorsed a moratorium on outsourcing is because the outsourcing policy based on A76 competitions was conducted in a way that was not consistent with the public interest. There's never been systems in place that have allowed agencies to actually track the costs and savings, if any, of A76. The A76 process itself has been found by independent third parties such as the DoD IG and the Government Accountability Office to be systematically biased against in-house performance because of the vast overstatement of overhead costs that are put onto the in-house cost estimate. And I can talk about that further. And then there's the fact, and it's very interesting to hear my fellow panelists talk about the importance of transparency. You know, one of the reasons that federal employees have been the exclusive targets of the efficiency initiative is because we are so transparent in the budget process. Anybody looking at an agency's budget, DoD or any other agency, can see exactly how many federal employees there are, what they do, and how much they cost. But the same has never been true for the contractor workforce that is, in many cases, many, many times larger than the federal workforce in the civilian in-house workforce in any given agency. Consequently, the moratorium on A76 was imposed to exist unless and until agencies could compile inventories of their service contracts that would allow them to bear the same kind of scrutiny that federal employee workforce bears on a continual basis. We want to know, and the public deserves to know, given the hundreds of billions of dollars spent on service contracts, exactly how many there are, what they do, and how much they cost. And in that context, because, and you can see in my written statement, there's an exchange between Senate Armed Services Chairman Levin with the person from DoD in charge of the Efficiency Initiative, where he admits that in the Efficiency Initiative, contractors have been spared any kind of scrutiny or any kind of proportional request for sacrifice because they're invisible in the budget. Nobody can tell exactly how much they cost, what they're doing, and how many of them there are. And so because of the fact that we're easy targets because we're visible, because of the transparency, and I'm not complaining about the transparency about federal employees, it's as it ought to be. There just ought to be equivalent and comparable transparency to the even larger service contract workforce.
Now, it seems to me that there are certain inherently governmental functions, for instance, oversight on spending, what type of positions do you think should be performed by Federal employees?
Well, our position is that obviously inherently governmental functions should be performed by Federal employees. I mean, that's not just our position. As you know, I think there doesn't even seem to be any disagreement about that. There's always going to be disagreement about the definition of what is inherently governmental. It's a controversial concept, but we do have one both in statute and regulation that if we only enforced that, we'd be in a much better place than we are today. According the Army, the Department of the Army is the one agency in the government that has actually done a good job in creating a contractor inventory, and its initial findings are that there's about 45,000 inherently governmental jobs being performed by contractors right now. But there's also the concept of work that's closely associated with inherently governmental work and critical functions. In fact, the OMB's Office of Federal Procurement Policy is in the process right now of putting together a new definition of inherently governmental that will include the concept of critical function. And the FAR includes a long list of examples of work that specific examples of work that fall into the category of closely associated with inherently governmental. And it involves things like preparing budgets, writing regulations, evaluating contract bids. I mean, a lot of work that's currently performed by contractors that, even on the face of it, raises people's eyebrows because it's work that's so closely identified with the public interest, and that work where there's almost inevitably a conflict of interest when it's performed by a private business, that we would want it performed by employees of a Federal agency. Then there's also work that has been contracted out without any competition. The vast majority of Federal employees who lose their jobs to outsourcing do so when there's what's called a direct conversion. There's no cost comparison, there's no competition, there's often no private competition. Just the work is handed over to one particular contractor. And we have suspicions, since everyone in this room is a great believer in the benefits of competition, that competition lowers prices. And when work is handed over without benefit of any kind of competition, public-private or private-private, I think that there's certainly a good public policy argument to be made that at a minimum it should be subjected to some form of competition. And then, of course, there's the category of work that's poorly performed by contractors, either far more expensively than originally promised, or quality problems. And God knows we have a long list of headlines in the newspaper of contracts that are poorly performed for one reason or another, or very, very, very expensive, more expensive than they ought to be.
Let me ask a question about the controversies with regard to the costing methodology for analyzing whether particular functions should have been in-house or outsourced. Has the costing methodology for DoD, where there was predominantly more reviews on efficiency, been reviewed by other congressional committees?
Oh, yes, they have. I have a few different things I'd like to say, if I may, about the DoD's costing methodology in the insourcing context. But in answer to your question, the Armed Services Committees, which are the committees that probably have spent the most amount of time actually studying and analyzing questions of cost comparison methodology, have codified now twice in the National Defense Authorization Act for fiscal year 2011, and then again when the Democrats were in charge, and now again when the Republicans have been in charge in the fiscal year 2012 National Defense Authorization Act. 2 times that committee has codified and endorsed the DoD costing method that's been used in the context of insourcing. We're aware, of course, of the critique that has been put forward by CSIS of the costing methodology, and we have actually asked the Department of Defense to respond to that critique. It's interesting to us, however, our critique of A76 costing methodology has been validated by independent third parties. The Government Accountability Office and the Department of Defense Inspector General. So far, at least, the contractors have only been able to find one of their own to criticize DOD's costing methodology. I think the fact that, two separate House Armed Services Committees have endorsed this costing methodology, and that to date we have no independent third party that has validated in any way the CSIS arguments, gives us reason to at least have some faith in it. But we are absolutely, if there are flaws in that methodology, we would want them to be corrected.
And in fact, the non-DOD agencies do not have a public costing methodology. And of course, you've mentioned this, that the Professional Services Council has recommended using OMB Circular A76. Would that alleviate the costing methodology concerns raised by contractors?
I doubt it. I think that they're looking for some kind of issue to hang their objections to, and costing methodology is sort of the argument of the day. A76 is systematically biased, and we know that. Bipartisan majorities in both houses of Congress have also recognized that. The GAO has recognized it. The DODIG has recognized it. I mean, during the heyday of A76 outsourcing during the Bush administration, it's true that in-house bids won most of the time in spite of this rather enormous bias against in-house performance. I mean, the overhead costs are, it's not just double counting. It's, overhead costs should only be charged to the in-house bid when it's a cost that would that would go away when the work is outsourced. And of course, what the DODIG found was these costs continued even after outsourcing. So they were inappropriately charged to every in-house bid. And so A76 is just a deeply flawed costing methodology. It's possible that the OFPP will issue a new and improved A76, and we expect any time that OFPP will issue a costing methodology for non-DOD agencies to use in the insourcing context, because I think there's obviously in DOD, if half of the work that's considered for insourcing is because it's inappropriate for outsourcing and half is due to cost reasons, well, then there's a lot of money to be saved once these non-DOD agencies have an opportunity to perform these kinds of rational cost-based comparisons.
Okay, thank you. I yield back.
Thank you. I'm going to recognize now the General from Louisiana, Mr. Landry, for 5 minutes.
Thank you, Mr. Chairman. Ms. Simon, when you say that contracts that have been insourced to private contractors are perform poorly, are they poorly performed because they may be poorly managed? I mean, is it possible that the management of the federal government in some of those contracts, they may not be adequately supervising them or managing them properly? Is that possible?
Well, I wouldn't say that it's a logical impossibility, but it seems really doubly unfair to federal employees to blame them when they're performing the government work if it doesn't go well, and also blame them when it's been contracted out and it doesn't go well. I mean, federal
so
employees
would you say
can't
there's
win
a
in that
bias when they
situation.
manage those kind of projects?
No, I think that unfortunately there were in the course of hollowing out agencies that occurred in the great downsizing of the 90s, we did find ourselves with so much work contracted out that contract management itself was contracted out. And agencies lacked adequate in-house personnel to effectively oversee their contractor workforce. When the contractor workforce was 5, 6, 7 times bigger than the in-house workforce, things were completely out of control. And that is exactly what gave rise to the idea of insourcing work that's inherently governmental and
But the private industry has a record of being able to manage, there are management teams that easily manage 7, 8, 9 times their size and perform well in the private sector. And when they perform well, of course, you can see that they perform well because their profits go up. And so I just wonder, the problem I have is that it is easier, and especially in times when this country is broke and American families are having to tighten their belt and cut certain things, whether it be going to the movies or not taking that summer trip to Disneyland and just going to the park instead. It becomes, I guess, easier for us to be able to look into, especially when we're insourcing, to be able to eliminate programs that are not useful. But when you load them up with federal employees, they seem to become difficult and become this animal that you're not able to properly cut when you should be cutting. I guess that and so those are my two concerns. Is that one, are we properly managing our private contractors? I have yet to be able to, even before I came to Congress, find a government agency that really is as proficient as the private sector. Now, I will admit my bias. I come from the private sector. So I just mentioned that. I did want to just ask Ms. Hamilton a question before I run out of time. Why do you think your contract was canceled?
Excuse me. Well, I only have what was given to me by the Coast Guard in the FOIA request, which is it's based on cost, and that's all I can really go on.
What
is
is your feelings
stating
on it, though?
Well, the numbers. There's a lot of people on the contract. It did make up at 23% of all the contracts that they have insourced over the last couple of years. So I guess it's numbers. They have they're under pressure to cut contractor positions by the agency that oversees them.
But you believe that you're creating a cost savings to the Coast Guard?
Oh, there's no. I am creating a cost savings, yes, but
Right.
insourcing these
So why would
positions,
there
I
be-
don't believe.
So why would there be pressure for them to? There should be pressure for them to save in the budget rather than to spend more money. So what's the pressure?
I think it's just the appearance of numbers being cut. They're being asked to cut by these jobs and save this money, and then they're producing a document that's saying it is saving $5 million, and it's coming out of their pocket, and then I guess it goes over the federal government's pocket instead of the Coast Guard's pocket. So it creates that appearance or illusion of saving some money from that agency, when in fact it's not. It's just coming from a different purse.
I see. Mr. Chairman, I yield.
Thank you, Mr. Landry. We're going to recognize now Mr. Kreitz from Pennsylvania for 5 minutes. Mr. Kreitz.
Thank you, Mr. Chairman. I was actually going to ask a couple of questions other than Ms. Simon, too, to give other people a chance to talk and give you a chance to rest a little bit. Now I'm going to, let me get my papers in front. Mrs. Hamilton, you had mentioned that where in your testimony you had 75% of your workforce you lost with a Coast Guard contract. Is that correct?
That's correct.
How much notice did you get that this contract was going to be eliminated, or you weren't going to get a follow-on or anything?
Well, they called me on Christmas Eve, as I stated, and said, and the jobs were posted that evening. Through the FOIA request, we did see that they had sent out a notice. However, it was sent to the wrong address. So if it was sent to the right address, that would have been maybe 6 months, but that didn't happen.
Oh, so they sent a notice out, but because it went to the wrong address, you didn't get that 6 months notice? Is that what
That's correct, and we brought
Okay.
that to their attention when we met with them.
Okay, all right. The contract you had with the Coast Guard, what was your margin, would you say, on it?
You mean our profit?
Yeah,
Probably around 6%.
6%. And but you were still saving the Coast Guard money and making 6%.
Yes.
Okay, all right. Ms. Carroll, you lost work, and it looked like from your testimony about 25% of your workforce.
It was 16% in the last 18 months, with another 15 potential.
Okay, how much notice did you get that this contract was going to be eliminated?
Well, notice is a funny thing, because we get lots of rumblings, okay? We get, oh, this is going to be insourced. We hear from our people this is going to be insourced and things like that. So we did get some notice, maybe 4 to 6 months notice on some of these contracts,
Okay.
one of which was canceled before the last option year.
Yeah.
And so the official notice versus the rumblings that go on, and when people are approached and told to apply for jobs when we haven't even been told that official decision is made, is a real problem.
Okay, thank you. Mr. Baines, you cited a CRS report, and I missed what report, what the title of the report was.
Yes, sir. It was functions performed by federal contractors, an overview of the legal issues. Oh, excuse me. It was functions performed by federal contractors, an overview of the legal issues. It's the cite to it is in my my testimony.
Okay. I went through rather quickly, and I didn't see it. Thank you very much. Now, for the three of you, I have some data here in front of me, and was curious if you were aware of it. There's a report by the Office of the Director of National Intelligence in 2008 concluded that in the intelligence community, contractors make up around 29% of the workforce, yet they account for nearly half of the personnel budgets. So obviously, there's an issue. And I think what you see from the Federal Government is that we have a way of making a one-size-fits-all solution. And I think you can cite personally that one-size-fits-all didn't fit your because you were doing good work. But when the Federal Government moves, it's a huge morass of people that move and trying to save money. And I'm on the Armed Services Committee. I used to work for a member that was Defense Appropriations. And what I can tell you is when you go into country in Iraq or you go into country in Afghanistan, there's way more contractors than there are military personnel. And it's a huge problem because the management, as Mr. Landry cited, is tough because there's so many moving parts. And I think things like this, what I just cited with intelligence, is that it's not working as it was set to be. But it works in some instances. You can cite that, but it doesn't work in all instances because there are some functions that are inherently governmental. There are some functions that are better done within the government, and it's not a perfect system. And I think it's great that we all can sit down here and talk about this. One thing that Ms. Simon brought up that I think is very interesting is that of all the insourcing, 17,000 in-house positions created in DOD, 6% of them were displaced small businesses. So it's not perfect, but it's close. Go ahead.
That number is a very interesting number, but numbers can be used to tell many stories. The reality is maybe there's a big company that has 800 positions. Okay, so are we talking percentages by contract? You have to look at how many small business contracts they are and what percentage of small business is being insourced versus large contractors and what percentage. That 6% doesn't really mean very much to me.
Well, it says where the prime contract holder was a small business, 6%.
Of the money of what? I don't really understand that number.
Ms. Simon, can you address that?
I would have to get back to you with the details, but I believe it's of contracts.
Okay. And my time has expired. Thank you, Mr. Chairman.
Thank you, Mr. Kreitz. We're now going to yield 5 minutes to Mr. Schrader from Oregon for his questions.
Thank you, Mr. Chairman. I'm just trying to get a handle on the fairness in the contracting issue area. And reference is made to each agency, I guess, gets to pick how it wants to define what cost should be allocated to a contract. I guess I asked Ms. Simon and Mr. Baines that question.
I'm sorry, I'm not sure I understand the question.
In other words, there doesn't appear to be a standard methodology for the Federal Government to include, a set number of costs, whether it's your variable costs, direct costs, overhead. I mean, all these.
As we
it's up to each agency. Is that correct?
Well, not exactly. As we speak, only the Department of Defense has issued and had codified into law a costing methodology for use when making insourcing decisions that are not based on cost, as opposed to based on whether the work is inherently governmental, closely associated to inherently governmental, poorly performed.
Seems like cost
contracted without,
providing it's not national security interest. It would be
non-DOD agencies right now are not insourcing for cost as far as we know, because they are waiting for OMB to issue a costing methodology that they can use when their insourcing decisions are going to be based on which is the lowest cost.
When is that
provider.
due, or do we know?
I have no idea. They are on their own schedule.
You indicated at one point, well, sorry, Mr. Baines, a comment on that also?
Yes, sir. When you're looking at what the costing methodology is for the Department of Defense, I mean, Ms. Simon is right in her exposition of what the field of play is. But the Directive Type Memorandum 09-007 is the Department of Defense costing methodology. That one was talked about in the Ike Skelton Act, and it basically was reviewed at that point. The interesting thing about it, and from a fairness perspective, is that there are two sets of numbers that are made in this directive type memorandum, or that are used. One is the set of numbers that's used to justify insourcing, and then the other set of numbers is used to report to Congress how much money you need, and or how much money the agency needs. The number that the agency needs and reports to Congress is up here. The number that is used to justify insourcing is down here, and it's less. So I didn't think the government was supposed to make a profit in its appropriations, but that's one way that.
So there's a mix and match, and there was a report to two different numbers using different variables.
Yes, Your Honor. Or yes, sir. Thinking
that's
I'm in
okay.
Court. Sorry. But it's an interesting memorandum. When you look at it, there's just two sets of numbers in there. There's one in the front that talks about reports to Congress and
I see.
What
So the reporting is different than the costing, actually, to some degree.
Yes, sir. And that's our concern, is the full costing methodology. That I would echo the chairman's concerns that I don't think the DTM actually has a full costing in it on the insourcing side. I think it does on the report to Congress side, but we don't. No one ever sees the insourcing side. That's secret. That's we don't. I can't. It's under a protective order. I can't tell you what it was for the Hallmark contract here today.
Okay.
But I can. But Ms. Simon is right. You can go to Congress and you can see what the agency asked for, but you can't see what the justification was.
Well, and I'd also like to add, of course, what Mr. Baines says may be true, but it's also true that the true costs of service contracts are truly invisible in the budget process. And the costs of hiring federal employees and the full lifetime costs of hiring federal employees are extremely transparent, known to all of us in great detail.
Appreciate that. You mentioned the CSIS critique and stuff. Could you elaborate a little bit on that?
Well, I only raised it because it's certainly the contractor lobbying organizations and pressure groups have tried to make great fanfare out of this report that we're not sure if they commissioned it or not. We don't really know what moved CSIS to suddenly jump into this arena. But they produced a report, and like I said earlier, we have formally requested that the Department of Defense respond to the criticisms that CSIS has made. From our own cursory review, we didn't find them persuasive, and what we find least persuasive is the recommendation in the report that the government revert to A76 as a costing methodology, because we know that that's a fatally flawed methodology.
Thank you very much. Ray, you'll back.
Thanks very much. And again, thanks to all the panelists for coming in today, and thank you for the questions. I'll take a few minutes now and go down with each of the witnesses and ask a couple of questions. Ms. Hamilton, tell me a little bit more about your contract. You spoke briefly about the services that you were providing. Could you go down that list again of what you were actually doing under your contract?
Sure, absolutely. What we do is we perform professional qualification evaluation of merchant mariner credential applications and safety and suitability screening of these applications as well. So basically, the criteria is established by the Coast Guard, and we simply administer. It's routine and administrative function in nature. SAC does not, it's not involved in any exercise of government discretion, so it's just administrative.
So it was a personnel-based.
It's personnel services, yes.
And I guess my question, Ms. Simon, you talked about the horror stories. The horror stories were either contracts that had been canceled or contracts that were or that were performing inherently or near inherently governmental functions. I guess my question to you is, what she just described, does that raise your eyebrows as to whether or not it's inherently governmental?
If Ms. Hamilton says that she learned from the agency that the work had never been categorized under a Fair Act inventory or otherwise as inherently governmental, I have no reason to doubt the truthfulness of her statement. Whether or not it's closely associated with inherently governmental work is really a judgment that's inherently governmental. I think that's for the agency to decide. It's not really, I'm absolutely a layperson when it comes to these kinds of distinctions, but there are people in the agencies who are much more knowledgeable about the integration of the work of the agency and are in much better position to judge when work is a critical function for an agency or whether it's closely associated with inherently governmental.
Ms. Simon, give me a few examples of what wouldn't raise your eyebrows, of something that to you is absolutely non-inherently government.
Well, I'd be happy to answer that question, but just I want to put my answer in a little bit of context. I'm sorry that Mr. Landry left because, one of the arguments that contractors, the most compelling arguments that contractors have, I believe, made in their own favor is that they're essentially disposable. You can hire contractors for temporary needs, for surge situations, but not necessarily for ongoing functions that are core to the mission of an agency. And I think this concept that once a contract is let to a contractor, the contractor has some kind of a fundamental right to a continuation of that work in perpetuity seems to be certainly counter to everything I know about the free enterprise system and what people can expect from their government. There are jobs that are commercial in nature and that
what would some of those be in your mind?
I think that, I guess the rule that I personally use when I analyze this kind of issue, I look at a business, and if a business has 100% of its work is government work, that makes me think that business might be inherently governmental.
If I was the food
absolutely
service,
no customers outside of the government, and that there is not that good or service is never exchanged solely in the private sector.
if I was the food service provider in this building, and that was 100% of my business, so 100% of my business was providing services to the government, would you consider that to be inherently governmental or commercial?
I'll tell you a food service function that I do think is inherently governmental, and that's the food service in a VA hospital. And that has been inappropriately contracted out in far too many cases.
Why is the food service in a VA hospital inherently governmental?
The veterans for overwhelming majority of the employees of the VA who do provide food service are veterans themselves, and providing, veterans who are in a VA hospital are acutely ill, of course, and they often have very special dietary needs. And the integration of food service is actually very highly integrated with patient care in a VA hospital, and it is part of the internal functioning of the holistic care of a veteran who's in the hospital. And often what's happened when food service has been contracted out solely for cost reasons is people get inappropriate meals that might have food or additives in their meals that are actually counteract the effectiveness of the drug regimen they might be on, or that they're only available certain hours, and so people are forced to have frozen meals that are, that also vary from either their taste or the regimen that they've been placed on by their health care providers.
Isn't food service provided commercially?
Is a great example. Is food service provided commercially
at every hospital other than VA hospitals in this country?
Of course it is, but I think that other hospitals, private hospitals, don't outsource their food service.
I'm sorry, what?
Private hospitals don't outsource their food service to patients. Selling a hamburger to visitors, sure, that's commercial.
Okay. You mentioned before, Ms. Simon, that to your knowledge, that it was only the DOD that was doing this on cost basis. I think you said they're the only ones that had come up with the actual rules, and that to our knowledge, there were other.
To my knowledge, yes.
Yeah. Who was your contract with, Ms. Hamilton?
The Coast Guard?
And the Coast Guard falls under what agency?
Department of Homeland Security.
Ms. Carroll, your contract was with whom?
Our Air Force One with the Department of Labor.
Department of Labor. Is that under the Department of Defense?
No.
Is it fair to say then that in the real world what's actually happening is there are other agencies other than the Department of Defense that are doing this supposedly based on cost? Okay. Ms. Carroll, tell me a little bit more about the Department of Labor contract that you had. You didn't get a chance to talk about the specific examples, and I do think the specific examples are real. In fact, the reason we're having this hearing is because I was approached by somebody who went through something that was very similar to what you folks had gone through. It was a map maker, a cartographer who showed up at work one day to find out that he had been insourced and that all of his employees had been hired by the Federal Government. And when he inquired as to whether or not the employees were willing to do that, he was informed that they were actually getting paid 20% premium to go to work for the government over what he was paying for them. And it was in large part that experience that drove this hearing today. So I think the individual experiences are real. Ms. Carroll, I'll be curious to know yours.
In the Department of Labor, as I said in my testimony, we were not the prime. We were a sub. We were working with a minority business. We had been in that library a number of years before, so we knew the library. And they just said, a lot of the things we're hearing today come down to the way contracts are managed. I totally agree. That's what someone said. The problem is that the government has to step up and manage these contracts right. When you say in a food service that, you know, the right thing isn't served, if there are standards of performance and they're well written, then the right things will in fact be done. And I know many contractors will do the right things even though it's not written in there. Mm-hmm. So in the case of the Department of Labor, 8 weeks before the end of the contract, we were notified that the contract would not be renewed nor recompeted. We had no indication of why that would happen, except we knew that the COs, the management of that contract, the COTR, changed all the time. So they really didn't understand what was going on at all. And they somehow had the idea to pull that work in. We had 2 librarians that worked there, and 2 of the people were insourced. The rest were just laid off. They gave us no time to really prepare for that kind of an action. And since we weren't the prime, we couldn't motivate the prime to go ahead and do FOIAs and do various things. They just said, you know what, at some point it's worth just going on, and they did.
Ms. Carroll, you also mentioned something that I'm not familiar with, which is poaching. To me, that's shooting an animal that doesn't belong to you. What does it mean in your world?
Well, not necessarily shooting, but taking an animal that doesn't belong to you. How about that?
Is that the term for hiring away the employees and so forth?
Right. Yeah. You do a very extensive recruitment process. You hire people. You train them. They work, and the government comes in and suggests that this person apply for a government job. Now, there's 2 kinds of poaching. Okay, there are some contracts we have, we know this is going to occur. We know we're going to hire people and eventually they're going to become government, and yeah, they post the jobs, but everybody knows that that person is wired for that kind of a job. That's kind of voluntary. The individual has the right to choose to apply for a government job that's posted. Okay, but it's the involuntary poaching that really is very distressing. Our project manager at an Air Force base in California was told before we were told that the contract was officially going to be outsourced. Of course, there was rumblings. She was told, your job is being posted, go and apply for it.
Do you have any idea what it paid in that particular circumstance?
No, I do not know that. I could get you data on that. I don't know what GS level it was. I never did that cost comparison, but I could get it if you'd like it.
We talk about cost comparisons, and I'm going to ask Ms. Simon a question in a few minutes about some of this supposed systematic bias in the A76 process. I think you mentioned specifically about overhead. Mm-hmm. Are you convinced, Ms. Carroll, that when you do the cost, or when the departments do the cost comparisons, that they are taking into consideration all of the costs that they should when they cost the government side of things, when they cost the government option?
No, I'm not convinced that they do cover it. The problem is that government life cycle costs for employees, for benefits, are in many different pots, sometimes not even in the same organizational pot. And so I don't think it's that transparent a process. I think you'd have to go through all kinds of routes in order to really know what the full life cycle costs of these people are. On the other hand, with a contractor, it's very clear exactly what the costs are.
You and I were talking before the hearing about a circumstance with a posting overseas. Would you like to share that with the panel?
Yeah, we had a contract, U.S. Air Force Europe, USAFE, and we were doing, we were performing very well. Before the end of the contract, they decided they would not exercise the last option year, and they said they were insourcing. Unfortunately, the German labor laws and the U.S. agreement requires those people to come back to the United States, so they couldn't be directly insourced. So some of the people just were out of jobs. But what happened was very interesting, that the government never filled some of those, still hasn't, months later, still hasn't filled those positions. We are hearing through our previous project manager, who still is in Europe, that the positions are not filled, and what they're doing now is they're paying people to go on duty to Germany. Now, was this figured in the cost? I mean, what is the accountability and what is the metrics and the measurements after the fact on whether this really works? We know a couple of the positions are still vacant, which means there isn't good data for promotions, for career paths and other things. So the servicemen and women are suffering.
You raise a good question, something that I heard from all three of the panelists regarding finding out about the process. Mr. Baines, given the decision in the Hallmark case, what methods, what avenues are available to Ms. Carroll if she wants to find out how the government costed that project?
Mr. Chairman, I don't think there are any avenues at that point, because if you can't file in the Court of Federal Claims, if there's no jurisdiction there, then you can't get a protective order to look at this data. So, and the government takes the position when you ask for it under the Freedom of Information Act that it's source selection information. That's secret. So I can't tell you what the numbers were in the Hallmark case sitting here today, because they're still under a protective order, but I can tell you that when you scrutinize them, there's two aspects that are totally out of whack. One is how many people it would take to do the job internally in the government, and then two, what are the full costs of performance of those individuals. And when you look at them and scrutinize exactly what's going on and exactly what the Air Force is going to do in the future, it doesn't make any sense at all. And now, under this decision, there may not be an opportunity to even find out ever.
Ms. Simon, I'll ask you, what's wrong with making the process public? What's wrong with sharing the information with the contractors, with the public? What's wrong with granting standing to the businesses that have had their contracts terminated?
Well, I'm listening to the three panelists. All I could think of was, welcome to our world. This is the exact same situation that federal employees only, I'd say we're in an even weaker position. This is the same kind of situation that federal employees face in the outsourcing context. We still don't have standing ever to go to the Court of Federal Claims. We're allowed to be an interested party and intervene, but we can only do so when we get the information on the in-house bid, the bid that was made on our behalf, and the contractor bid after it's too late to file a protest. We are in a
certainly
complete
somebody in the
veil
government
of
has that
ignorance,
information, right?
but not us.
Who are you in that circumstance?
The employees that are losing their jobs, the employees that have.
But your counterparts to what Ms. Carroll, Ms. Hamilton do. I mean, the bosses, I guess, have access to that information, don't they?
There are designated individuals within the agency that have that information, but certainly not the people who are affected by the decision to outsource the government work. And there's effectively no appeal right, because by the time we get the information, again, through FOIA requests or the intervention of members of Congress, it's too late for us to file any kind of protest or do anything about it. We are for transparency. On the other hand, I think that be careful what you wish for. If contractors are granted the right to engage in endless litigation whenever there's any possibility of having their contract terminated, I think agencies will certainly think twice before they sign these contracts, because it certainly raises the stakes and raises the long-term costs of engaging in a contract with a private company, because you don't have the flexibility that contractors use as their best argument for themselves. If you can never terminate a contract because you no longer want to perform that function, or you'd like to compete it in another way, or bring it back in-house, and the prospect is endless litigation, why would you ever want to subject yourself to that?
I think there's a distinction. We may be using legal terms here that mean different things to different people. To me, the termination of a contract is one thing. The expiration of a contract is another. The expiration of a contract would be the ending of a contract by its own terms and is completely contemplated in the document itself. The termination of a contract is the breaking of a contract.
Yeah, I think that what Ms. Hamilton referenced was that the government didn't exercise all of its options. Is that correct?
No, that's not correct. I'm sorry.
Sorry. I'm sorry.
I think there has been testimony that some of the contracts discussed today were that, but other ones were actual terminations. So I guess my question to you is to try and focus here is fairly simple, which is, what is wrong with giving the managers of the private businesses the same information that the managers of the government projects have?
I think that we have no problem with the concept of notice. Notice is one thing, and the provision of all the internal costing information prior to the decision is another. And we have some misgivings about that. Notice, no problem at all.
All right, and then lastly, I do want to touch on this issue of overhead, because in my world, Ms. Simon, by the way, you're the first person I've heard in Washington, and I mean this slightly tongue-in-cheek, that has said that this place is inherently transparent and everybody understands what's going on. You may be the only person in town who believes that.
Oh, I said that with respect to federal employees, not the government as a whole.
That's right.
Certainly there's the contractor workforce.
But in regards to transparency, as a lawmaker, as someone who's ultimately called upon to sort of choose between these two things, obviously we set policy and that it gets implemented at a different level. If you present me with a private contract for Ms. Hamilton to provide the services to the United States Coast Guard that she described, I know exactly what that is going to cost. I know how long it's going to cost and what it's going to cost on a year-to-year basis. I have what in the legal world we call a liquidated sum. I know it's going to be $100,000, whatever the number is. If you come in and tell me, well, I also want to hire the same number of government employees to do that exact amount of work, I would suggest to you I have no idea how much that is going to cost, because what I'm doing now is I've got permanent workers. I don't have a short-term contract. I haven't hired contract workers to do this work. I'm actually taking federal workers and putting them to work on this particular job. You mentioned that overhead should not be counted. It strikes me that that's bizarre. No one in the private sector would ever say those words, that you can't cost overhead into what you're doing. And it just strikes me as odd that you've taken the position today that you actually know what the government is paying for these services, because I think the exact opposite tends to be the case. I'm going to yield back to Ms. Chu, and I will get you a chance to close.
May I respond?
Very briefly. Let me get Ms. Chu, and she may give you the opportunity to do that. I've spoken for way too long, and I apologize for doing that. So, Ms. Chu, if you have any follow-up questions, I'll yield you as much time as you need.
Well, I'll just thank all the witnesses for coming and give you a chance to respond to that question.
Okay. I would not agree that when you sign a contract that specifies a certain amount of work to be done for a certain price, that's the end of it. One of the problems with service contracting is that that's often not the end of it. When new requirements arise, unanticipated events occur, it requires renegotiation, new task orders. There's often contracts often grow far beyond their initial terms and costs. In contrast, when you hire a federal employee, you agree to pay a certain salary or an hourly rate for when they're working. But each time you give the federal employee a new assignment or a new task, you don't suddenly raise their pay. You don't have to engage in a whole new negotiation over the terms of employment. There's a very useful term in every federal employee's job description, other duties as assigned. You can move Federal employees around. You can tell them to do whatever you want them to do, and they have to do it and there's no increase in cost. And I would also object to the assumption that once a Federal employee is hired, they're there forever. In the efficiency initiative in the Department of Defense, for example, the 600 employees that I talked about that DFAS hired when it insourced that work, because of the sort of zero, or it's not a zero sum, because of the fact that the efficiency initiative has a cap on Federal FTE, any new employees hired have to be offset with positions eliminated. So many Federal employees are going to lose their jobs, and many Federal positions are going to be eliminated in the context of the efficiency initiative.
Thank you. I yield back.
Ms. Chu, I'm finished. Would you like to give your closing statement?
I would just like to thank all the witnesses for coming. It was a very informative hearing today.
Thanks very much. I'll close with this. I do appreciate everyone's participation. I think it's been a healthy debate, and it's been helpful to me to help frame the issues. Ms. Simon, I especially appreciate your testimony. It's obviously counter to what positions I would take. And I would, but before we close, point out that actually it was Robert Gates who said that, in his opinion, this system within the DoD, the insourcing system, has completely failed to meet its goal to save costs. So often is the case, one part of the government is saying one thing, one is saying the other. In fact, I see some heads nodding negatively in the body, so I'll read the quote. "We weren't seeing the savings we had hoped for from insourcing as the Defense Department brought work from the private sector in-house," Defense Secretary Gates said on August 9th of last year. Again, thank you to everybody. Having the stories, not only from the private sector, but on the behalf of the Federal employees, is extraordinarily helpful to us. And as this subcommittee continues to focus on creating opportunities for small businesses to compete for Federal contracts, we will continue to investigate instances where agency actions harm small business and cost the taxpayer more money. Ms. Simon mentioned earlier today that most of the horror stories were probably contracts that were expired of their own terms or that were inherently governmental. I would suggest to everyone here in the room that that is not the purpose of this hearing. The purpose of this hearing and the purpose of the additional hearings that we will do will be to focus on the exceptions to those two things. I cannot sit here and defend somebody who was upset because their contract, that was a 3-year contract with the government, expired, and the government decided not to hire them again. That is the government's right, and it is the contract terms that set forth that. Similarly speaking, if you were doing something like trying to shoot people, I would think that that would be one of those inherently government functions that should be insourced. I want to focus, however, as we go forward, on the other things, the other exceptions to those two rules, where the government actually reaches out and takes things from the private sector that are not inherently governmental functions and that do not save costs. We are here on the Small Business Committee, on both party members I know agree with us, to protect the interest of small business. And to the extent that the Federal Government is trampling on the opportunities that are afforded to our small businesses, I know that both parties here will do everything we can to prevent that from happening. After today's hearing, I'm going to undertake 4 actions. I'm going to ask the full committee to follow up with the agencies mentioned by Ms. Hamilton and Ms. Carroll. Secondly, I'm going to send a copy of the transcript to the Office of Federal Procurement Policy so that they can they can look at the suggestions offered by our witnesses as they finalize their policy guidance. Third, I will send a letter to OMB requesting that each agency publish their insourcing guidance pursuant to notice and comment rulemaking, and that OMB and each agency ask them to impose a moratorium on cost-based insourcing until those rules are in fact published. Fourth, as we consider contracting legislation for this Congress, we will look at ways we can address standing for small businesses facing insourcing difficulties and ways we can strengthen the SBA's roles in this process. At this time, I also ask unanimous consent that the members have 5 legislative days to submit statements and supporting materials for the record. Hearing no objection, it is so ordered. Thank you all again. Thank you for participating. This meeting is adjourned.